Estate planning attorney Jeff Fouts here. So, as you've heard me say, in regard to revocable living trust, if you want a revocable living trust to work, you must transfer assets into the trust. No big deal. You still get your homestead exemption, you still get school tax exemption, no problem. Now I want to talk about a little bit of legal theory here. So I'm not trying to get too complicated, but I like educating people because I think it's important, all right, that you understand at least to some degree what your attorney's doing. So let's talk about it, the legal philosophy. If you create a revocable living trust and you reserve certain powers, then you're reserving the power to amend the trust, to restate the trust, to revoke the trust, to put property in, to take property out, to spend money, to control the investments. And because, oh, by the way, you're also called the grantor. The person that's creating the trust is called the grantor. That's a fancy old English word. Another word you can say is the trust maker, but it's the same thing, grantor. So not only that, but you are the trustee. The trustee is kind of like the manager for the trust, and they manage it on behalf of the beneficiary. So you will be the beneficiary. So you're the trust maker, the grantor, you're the manager, which is called the trustee, and you are also the beneficiary of it. So you hold all three positions of authority, okay? So because you hold all positions of authority and you have the right to do whatever you want to, then the IRS calls that kind of trust a grantor status trust. Now don't let me get too deep in the woods here, the weeds, okay? So grantor status, that's very important. The reason it's very important is because that means that you do not have to get a separate tax ID number. You do not have to file a separate tax return. You continue to file your tax return just like you always have. There in no way changes. So that is very important. Your life does not get more complicated. But you know, yet some people don't understand this. I had a client, we were redoing their estate plan, and they said to me at the signing, "Jeff, are we still going to have to file that tax return?" I said, "What do you mean, and to file the tax return?" They said, "Well, our attorney told us that we were going to have to file a tax return, and I've been filing it for 8 years." Remember, they had the old estate plan, and we redid it. Okay. And their attorney was a very nice lady. She was a general practitioner. I know her. I'll candor. I know her father. So, but this person, they were very nice, but they did divorces on Monday, criminal law on Tuesday, disability on Thursday, a will every now and then probably, and a revocable trust, who knows how infrequently. How do I know that? Well, they're general practitioners, but not only that, but they told this person that they needed to get a tax ID number and file a tax return. That was incorrect. Totally, 100% incorrect. And so we had to clean that up, and we had to make it so that the client didn't ever have to do that again, you know, while they were alive. And so it's a shame, but people don't understand how these things are simple, and sometimes they make them more complicated than they really, really have to be. So anyway, grantor status means by the IRS, you don't have to seek any special permission. It already qualifies. If we could ever help you in the future, like review your estate plan, just let us know. Have a good day.